docket. That is case number 106318, State of Kansas v. Alejandro E. Betancourt, Jr.
Mr. Betancourt appears through counsel Michelle Davis. May I please reserve 4 minutes for rebuttal?
4 minutes is granted.
Thank you. I think what I'd like to do today is mostly talk about the first issue and then submit the remaining issues on the brief. This is a case where Mr. Betancourt was convicted of both types of first-degree murder. The state's case against him was based on the fact that he was driving a vehicle, and two young men in that vehicle, both 17 years of age, approached a house and fired some shots at the house. And a young boy who was at the door of the house was killed from those gunshots. And so the state charged criminal discharge of a firearm at an occupied dwelling, resulting in a death, which would be felony murder, and then also premeditated murder, and then also the discharge of the firearm at the dwelling. And Mr. Betancourt was convicted on an aiding and abetting theory because he was the driver of the vehicle for all three of those crimes. And his defense...
Excuse me, counsel, the jury verdict form was clear that he was unanimously convicted on both the theory of premeditated murder and felony murder, right? Each of those reflects a unanimous jury verdict.
Yes.
Okay. So how does the first issue get you anywhere? Even if there was error, even if it was reversible on premeditated, he stands convicted of felony murder, correct?
That's true.
Okay. So what do you really get as relief out of that issue?
Well, the sentence for felony murder.
Okay. So he'd be resentenced, but there wouldn't be any relief from the conviction itself.
Yes, because our issue 1 only challenges the premeditated murder conviction.
Okay. Thank you.
So his defense at trial was they were at a party, there was a lot of drinking going on, there was drug usage, and basically the defense was this was drunk talk. Any talk about going over and shooting at this house, that one of the young men in the car, there was a state's witness who testified that one of the young men in the car talked about shooting at the house or shooting at someone. And he's the only one that there was testimony that there was that direct statement. And Mr. Betancourt's defense at trial was, I didn't think they were going to shoot anybody. His attorney said this was just drunk talk, and therefore he wasn't aiding and abetting a premeditated intentional killing because he didn't have that, in his state of mind, he didn't have that intent. And so our first issue takes challenge with the court's premeditated murder instruction because it states that Mr. Betancourt intentionally killed and that such killing was done with premeditation. And the error that we are alleging is because it doesn't say that Mr. Betancourt had premeditation here. And so a jury could believe that as long as somebody had premeditation, which in the state doesn't require very much, it requires just some thought beforehand, that one of the young men who was the actual shooter at some point thought about it beforehand, that they could convict Mr. Betancourt without necessarily finding that Mr. Betancourt had premeditated an intentional killing. And so this issue basically would only apply in an aiding and abetting situation where there's some intent to do some crime. I mean, obviously there was going to be some malfeasance here. These two young men are approaching the house seeking some sort of vengeance or revenge. And so there's the aiding and abetting instruction talks about aiding and abetting in order to commit a crime and therefore being responsible for the crime that's committed.
The crime that's committed here is premeditated murder. It's not any crime, it's the crime. I understand our previous cases in Englehart and Overstreet and how there could be confusion, but the concern in those cases that the instruction on aiding and abetting wasn't given in this case. In this case, it was a pretty straightforward aiding and abetting, and the crime was first-degree murder. So I'm not sure where you get when you look at the instructions as a whole. How would the jury conclude that it was another crime or didn't require the element of premeditation?
Well, our argument is premised on the fact that you have a jury looking at these instructions and that they could be interpreted in a certain way. Certainly you and I, as lawyers looking at the instructions and knowing what they're supposed to say, could correctly interpret them. So our argument is based on the fact that in the aiding and abetting instruction, when it says aiding another to commit a crime, for example, shooting at a house, you're then criminally responsible for the actual crime that's committed. It's sort of turning that into a somewhat felony murder type instruction. And so our argument is based on the fact that a jury could misread this because they were not instructed to directly find that Mr. Betancourt acted with premeditation. And I would note that they have since that time changed the aiding and abetting instruction so that it talks about, I think I did a 609 letter with the corrected instruction where it talks about being responsible for a crime if the person has the mental culpability required to commit the crime and intentionally aids another to commit the crime. So both times you're saying the crime. So it's very clear as to what the jury has to find. Versus in the aiding and abetting instruction that was given in this case, it just talks about you're aiding a crime. And then you're criminally responsible for the crime that's actually committed. So that could be turned into some sort of felony murder type instruction. That's our argument.
And we're firmly convinced the jury would have reached a different result. Why? This is clearly erroneous, right?
Well, you know, that would be, if the jury was to interpret the instruction in the manner that I've argued, then that would obviously be a misstatement of the law. And that in this case, given the evidence that was presented, that there is a real possibility a jury could maybe not have found premeditated murder.
Well, the
that a
evidence
jury wouldn't have
presented
gone.
was, there was evidence presented that Mr. Betancourt was directing this to happen. I mean, it wasn't just that he was driving the vehicle. He was going over to the home of where he knew the victim lived and wanted to shoot the house or shoot at the victim. And I mean, there's no question that he wasn't just driving the vehicle over to have these people do it. That he was the one instructing.
Well, the testimony that comes from is the witness who cooperated with the state, and that.
Yeah, I mean that's evidence.
Right, and what he quoted was there are no statements directly from Mr. Betancourt. It was all the statement of the 17-year-old in the car. That the 17-year-old Eddie, who was the first shooter, said, you know, and it's drunk talk again, is the allegation here that we're just going to go shoot. We're going to go shoot at the house, or we're going to go shoot the house. It's one statement, or we're going to go shoot someone, and that's it. I mean, that's the only evidence here that shows any, other than just you would infer from the actions. And so it's our argument that a jury could have decided that this was felony murder.
Ms. Davis, are you familiar with some of the more recent Court of Appeals decisions holding that the aiding and abetting is not an alternative means?
I am.
And why would you say those decisions are incorrect, or would you agree with them?
I think the best argument I would have on that is that this is interesting. The alternative means between acting as a principal and acting as an aider and abetter is alternative means, because to me that's sort of course, a causation element. And my best argument would be when you're alleged to have acted as the principal, you're saying you caused the death directly. You did the act. And when you're charged, your causation as an aider and abetter is that somehow your actions assisted the principal in being able to do their action. And so that's a different that's a different causation requirement in terms of the proximate cause of acting as a principal and the proximate cause of acting as an aider or abetter. I mean, for example, if I, as an aider or abetter, commit an act, and that act, if I give you a gun and say, go shoot somebody, and then a year later you use a different gun to go shoot somebody, then I have a defense here that I wasn't the proximate cause. I aided you, but I didn't aid you in this crime. I gave you a gun, but you didn't use that gun to commit the crime. So there's some sort of causation defense there. And so that's a different type of causation than what would be required for the person that actually goes and commits the crime. And so therefore, they're alternative means.
Any further presentation,
No.
counsel? Any further questions? Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney Boyd Ishwood on behalf of the state of Kansas. I think that the first issue that counsel addressed was the instruction to the court or to the jury. And under this court's new analytical framework on how to address instructional error or claims of instructional error, I don't think we get past what would be the second prong, because there is no error. Because counsel can suggest an alternative that she thinks would be better, does not mean that the alternative, being the pattern instructions that the district court chose, was in error in any way. I think this court has on a number of occasions indicated that if the instructions given cover and include the instructions requested, in this case requested after the fact, that there is no error in the instructions given. So I don't think we even get to the reversibility prong of the analytical framework as I understand it. Especially in this case, when you take into account the fact that the prosecutor, in closing, tied all this information together, indicating that when we're talking about premeditation in these instructions, we're talking about the defendant's premeditation. And all that is, I think, succinctly stated in our brief. Unless the court has any questions about that issue, I'll briefly move over to the aiding and abetting as an alternative means. And I'm familiar with a lot of the Court of Appeals opinions that have come out, and I understand there's, at one point, it seems like there was kind of a discrepancy in the way they evaluated it, but that was, I think, the cases were pre-Brown. I'm not sure if there are any after Brown, but it just seems to me, it's always seemed to me, that what we're talking about is different levels of involvement. We're not talking about different means. When we're talking about principal and aider and abetter, there's always going to only be one means. There's just different levels of participation, and that's exactly what the aiding and abetting statute talks about. It. In the state of Kansas, we made a policy decision that if you're the principal or if you're involved as an aider and abetter, we don't care what your participation level was, you're on the hook. And so I don't think it can be considered an alternative means. Unless the court has any questions about the case in general, we respectfully request that the convictions be affirmed.
Any further questions? Thank you, counsel.
Thank you.
Reserve 4 minutes for rebuttal.
I'm prepared to waive rebuttal unless there are questions.
I have a question.
Certainly.
How do you respond to counsel's statement that the instructions, as they're laid out, correctly state the law? What in the instructions was an incorrect statement of the law?
Well, that the crime was done with premeditation instead of.
But
that
we've
Mr.
said that Mr. Betancourt did have to have premeditation, right? I mean, I don't know, why is that an incorrect statement of the law?
If you can read the instruction that way, when it says that Mr. Betancourt intentionally killed and that such killing was done with premeditation, I think the instruction says, and I think that's what it says. You can read it that way to say that means that Mr. Betancourt had to have the premeditation. Or you can read it to mean somebody had to have premeditation. Because when it says Mr. Betancourt killed, I'm sorry.
So you're not saying it's an incorrect statement of law, you're saying it's an ambiguous statement of law.
That could be read incorrectly. I am. That's right. Thank you.
Justice Breyer, do you have a question?
No, I was getting there. That's fine. Thank you.
Any further questions? Thank you, counsel.
Okay.
Thank you both for your arguments this morning. Court will take this matter under advisement. We now turn to the second case on this morning's docket. That is case number 106471, State of Kansas v. Sean Alderson.
May it please the court. My name is Sean Hatfield. I represent the appellant, Sean Alderson. Mr. Chief Justice, I would respectfully request 3 minutes of rebuttal time.
3 minutes is granted.
Mr. Alderson appeals to this court the denial of his pro se motion for release of restitution. And that's really the single issue presented in this case. And very briefly, by way of background, Mr. Alderson was convicted of first-degree murder and aggravated battery back in 1994. Ultimately, his sentence, his life sentence, was affirmed by this court. In addition to fines and court costs at sentencing, the defendant was ordered to pay just under $120,000 in restitution. That was in 1996, after this court affirmed his conviction, but remanded it back to the district court for resentencing before a different judge. That second judge on remand simply upheld or went along with the original sentencing judge's sentence, including adopting the restitution order as it was originally stated. Back then in 2009,
Excuse me, Counselor, is there any question on timing because of the resentencing? I think the statute says that the restitution order is good for 10 years.
that's correct. So, yeah, there is not an issue on timing. This, either way, was after the 10-year period of time in the
The
dormant
sole
period.
question is whether the courts entered an order that was a present order.
That's correct. That's correct. I mean, frankly, the issue before the court is simply, when did that restitution order take effect? And our position, of course, is the language that the district court used at sentencing, which may be an illegal sentence.
Let's get more fundamental. Is there any way that this trial court judge had jurisdiction to order a condition of parole?
I think, yes, he has a jurisdiction to order restitution as a condition, but he's required, and I think we note State v. Bowers, he has to be specific on the record in his instructions to the parole board.
Recently, we've said that we've vacated orders of electronic monitoring because we've said that a trial judge has no jurisdiction to order conditions of parole. And why aren't we dealing with the same thing? If it takes effect upon release, then that's a condition of parole, is it not?
That's correct, but our problem here is that the language used by the court at sentencing was unclear at best and would seem to indicate that restitution did not take effect immediately upon release or as a condition of a release, but took effect while he was in custody. And I recognize that would be an illegal sentence, but the problem is the language used by the district court.
And that language you're referring to is that defendant's release from incarceration should be made contingent upon defendant making restitution.
The
We read
language,
two different ways,
it can be.
clearly. Yeah.
And in the journal entry as well, I think it's two different clauses essentially. That first clause in the journal entry is restitution is owed, as set forth below.
What is the meaning then of, why do we care about that, given the statutory language, and focus on the word latter or later in 216604E? The last clause is that basically it's saying if there's incarceration, the court may specify in its order the amount of restitution if restitution is later ordered as a condition of parole, conditional release, or post-release supervision. So does that give them the right to order, presently order? Does the court even have that ability under that language of the statute?
Respectfully, I would say no. But again, particularly in this case, the importance of the district court using specific language, even assuming that it did have authority, if it did, it needs to be specific. Restitution is not immediate. The cases, I think both parties cited, Robart and Morrison, in those cases, the defendant had been released on parole or early release, and in both of those cases, the restitution order issued by the district court was very clear. This is not to take effect immediate. We have real ambiguity here, which led to the problem of the state's agent sending a collection note for delinquent, saying that he was delinquent on his restitution payment when he's serving a life sentence. That's the problem here, and that's why, even though it may be an illegal sentence, and the court may not have had jurisdiction, that's not an error attributable to the defendant. And certainly, in this case, the state didn't object to the language at the time of sentencing, and my review of the record, there wasn't a correction of the state's agent's actions for sending that delinquency notice to the defendant or the appellant when he was incarcerated. We should then calculate, based on the court's error, the restitution order took effect at the time of sentencing. In that case, when Mr. Alderson filed his pro se motion, the judgment was not delinquent, that's the right word, dormant at that time, and he should be released from that order.
Just talk practicality.
Yes.
If we determine that it was a present order and that it is dormant and it becomes unenforceable as a judgment, does that preclude the parole review board when it determines to release Mr. Alderson that one of the conditions of parole will be that he make restitution?
Absolutely, Your Honor. I think without a valid order from the district court, I don't think the parole board would have that authority.
But that's what I was asking you earlier. It's not the district court that orders conditions of parole. It's the parole review board.
That's correct. And so I think respectfully, in this case, when he was sentenced, in order for that to be a condition of parole, I think the district court had to have reserved the ability to, had to reserve the restitution request, and it was not properly reserved. I would submit to you.
Isn't all the judge doing is making a factual finding as to what the amount of restitution should be for use by the parole board if they order it later?
I think that's effectively correct. I think the court is preserving its jurisdiction to order restitution maybe later. But again, it just didn't do that in this case. The language used by the court said restitution is owed. It's immediate. That's the problem here.
Any further presentation, counsel?
No, Your Honor, if there are no further questions.
Any more questions?
Which result works better for you, for your client, do you think? To have this declared dormant or have it declared not authorized yet, that it doesn't happen until parole? Which, I mean, I can kind of see it both ways.
Justice, I can too. I think ultimately, though, the best results for my client, and probably the best result as a matter of judicial economy, is to declare this dormant. He's filed his request. It would comply with the statute. It's done. The rest of the sentence can be maintained, but the restitution order is vacated.
Any more questions?
Understanding we're here for this case, but doesn't that result then mean that all other inmates can have their accounts garnished every month for payment of an order, a restitution order?
No, I don't think that, no, because, I mean, I think the law is very clear. Restitution cannot be ordered while the defendant is incarcerated. It can only be ordered as a condition of parole. So I don't think lawfully jailed inmates can be subject to garnishment for restitution, at least. Court costs and fines may be another matter.
Anything further? Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney Boyd Ishwood on behalf of the state of Kansas. I think in this case, when we look at the comments of the district court at the time, I believe of resentencing and possibly at the time of original sentencing as well, I think what we see is the district court judge attempting to comply with the statutory provision. Maybe he didn't say it as clearly as he could have after review it after the fact, but I think the intent was clearly just to state that restitution was owed and that we've had this finding that restitution's owed. I don't know that the parole board is necessarily a fact-finding court or entity. So at the district court level, the fact that restitution's owed, the amount and to whom, and then I think he tried to comply with the relevant statutory authority at the time that indicates that the parole board or whatever it is at that time would be the ones to determine whether it was part of the parole. I think that's what's happened here. It's my understanding, and again, I expressed in our supplemental some frustration in this because I don't have access to some of the parties that may have taken action. I don't represent some of the parties.
Isn't the state of Kansas involved in all of this? Didn't the state of Kansas refer it to Municipal Services Bureau?
I think the state of Kansas did, but I think it was through a contract with the district court or the Attorney
who's the
General.
party to this action other than the state of Kansas and Mr. Alderson?
Well, I think MSB would be a party, and I think that the district court would be a party more so than the 18th Judicial District Attorney's Office.
They're a party to the issue of whether there was a valid judgment for restitution?
No, I don't think so. And that's the confusion, Your Honor. I think that the pro se litigant, as he's formulated the issue, merely addressed the original entry of the comments of restitution at the time of sentencing, and then I think the supplemental issues have brought it out to the issue of, MSB.
My question is, why aren't you standing here today representing the state of Kansas bound by the actions of the contractors of the state of Kansas?
Because I think, as I tried to express in the supplemental brief, at the time that this has been reduced to some sort of civil judgment, which it appears that it has been since that's a precursor to the the triggering of the contract between MSB and the district court. At that time, I don't think that the 18th Judicial District Attorney's Office is involved. I think that we have some sort of duty to see that the initial determination of restitution is followed through up until that point, and in which case we drop out. It matters not to the 18th Judicial District Attorney's Office how these third parties get paid, whether they get paid, what the mechanism is. We don't contract with MSB, as I understand it.
So why did you not refer this to the Attorney General for a briefing?
I don't know. I believe that we are looking into that matter. I think at the time, the attorney that handled the response at the time, I don't think we understood the full impact of what was happening. And again, Your Honor, we were addressing the pro se litigants' argument. And that argument was that the 10 years has started to run. And so we apply case law, which indicates that no, it doesn't start to run because you haven't been conditionally released.
I'm a little confused by that because I went to look at your supplemental brief and Natalie Chalmers stamps right on it as approved by the Attorney General. So
that's true.
I mean, I think you have a little bit of trouble trying to say left hand, right hand, and we don't know which one's doing what here.
Well, I took Justice Lukert's comment to indicate, well, why didn't we do it in the beginning, and why didn't we do it later? It's just, this is a confusing concept, and I think that we need to, if we just address the pro se litigant's claim, I don't know that we would need to include any other party, because the pro se litigant's claim is simply that the time has started to run and it hasn't. Now, what MSB has done And what the district court has done, or as a contracting agent, MSB with the district court or the attorney general in collecting on this, I can't answer for that. Like I said, our take on, our part on this is just to see that the original order is enforceable, and we will continue to fight for that. And by order, I don't mean the order of restitution. I'm fully aware, but the sentencing, the comments of who, when, how much, things of that nature.
But not presently collectible.
I don't think there's no indication that at the time the district court made that ruling that the district court was under the impression that it was presently collectible. That happened after the fact, and I do think that it happened based on the statutory changes, which makes, in my estimation, and maybe I'm wrong, but makes restitution collectible as an authorized disposition, even if you're incarcerated. That change happened after this case. So I do think that's where the confusion on perhaps the part of the district court, MSB, I think they kind of came in and maybe don't understand the difference between the authorized dispositions, which would apply at the time of sentencing, which would control. Because I think this court has said that restitution is part of sentencing.
Somebody representing the state of Kansas had to refer this to MSB as being a currently collectible restitution order. Is that correct?
I think so, and we don't know based on, and that's part of the problem. We don't know based on this record
And
when that happened and what was the process.
If that happened, then the state of Kansas, by whatever agent, has taken a position that is contrary to your argument today. Taking a position that there was a present order of restitution rather than a fact-finding for the parole board.
Well, I think that presupposes that that whatever entity, whoever it was that took this step, was keyed off of the district court's comments at the 1996 rehearing. I think.
I don't care why
Okay.
they did it, but someone from the state of Kansas took action that is contrary to your position today.
I don't know that it's contrary to my position today, because my position today was that it wasn't an authorized disposition at the time. They may be confused about what the authorized disposition was. So
Well, they said it was an
that's the why.
outstanding court obligation due immediately.
I'm sorry.
MSB took the position and
Yes.
served up Mr. Alderson that it was due immediately,
But
$150,000.
that's correct, and I think that what I'm trying to articulate, maybe I'm not doing it well, or maybe it just doesn't matter, but what I'm trying to articulate is that what did MSB take this action based upon? We don't know. I don't think it was based upon the district court's comments at the time of sentencing in 1996. It was some other thing. The frustration is...
And it was a mistake.
I'm sorry?
And it was a mistake.
I would think
And
so.
that's really what you're
That would
saying.
be-
It was a mistake, so if we took a contrary position before, we were in error, and today we're right.
I don't think I don't think, my estimation as an officer of the court, my estimation from the authorized dispositions at the time of sentencing, and I do think that this court has held that restitution is part of the sentence. So the sentence at the time that you committed your crime would control, and that did not authorize restitution when you're incarcerated.
Right. It didn't authorize anybody to seek collection while he was still
Well,
in
that as well.
prison. Yeah.
Yeah.
If I can put that in the language of the statute to see if I understand, the collection provision says, if after 60 days from the day restitution is ordered by a court, a defendant is found to be in noncompliance with the plan established by the court for payment of restitution. And then the rest of it says you can start proceedings. So are you saying that we cannot find this defendant to have been in noncompliance with the plan because the plan that the judge announced was based on the law that was in effect at the time of sentencing, which was that restitution became effective after release from incarceration?
That would be a reasonable way to formulate it, or simply that this new provision doesn't even apply. Because, like I say, if restitution is part of the sentencing, then the sentencing and/or the restitution law with respect to your case at the time you committed your crime would govern. This was not there. What was there was that restitution is not an authorized disposition if you're incarcerated.
Sorry, do you have any reason to argue why this statute would not be retroactively applied?
Because it's part of your sentence, and you can't, as an ex post facto, I guess you wouldn't be able to apply a change in the sentence that I assume would be more harmful to the defendant retroactively, I would assume.
That's kind of hard to decide, I think, which is, but it would change the condition of the sentences at least.
And, well, it would change the authorized dispositions. And again, I apologize for any if I seem confused. It's just that, again, we haven't had these proceedings that I'm aware of. I don't know who was involved. I have no idea. And I do think that this involves rights and of parties that I do not represent, regardless of who stamps the outside cover of the briefs. I think that maybe this court, in making some sort of ruling in this case, one way to handle it would be maybe to remand it back to the district court for further proceedings to determine what has happened, why, when, by whom, so we don't have to guess. I hate having to guess myself, and I assume that this court would hate to have to make a number of logical, factual leaps in determining what has happened here.
What would be the factual determination that would affect the analysis here?
Well, I guess it would determine, perhaps the court has talked about equitable remedies, and maybe you'd want to know why someone did something. It would definitely seem to impact if something was done by a mistake, or if something was calculated. That would seem to involve the equitable remedy that the court has proposed in the supplemental.
So you're saying if the referral to MSB was a mistake, then collateral estoppel would not apply?
I wouldn't think so. As we indicated in our supplemental brief, a misunderstanding, an action based on a misunderstanding does not seem to square at all with what I found. The prior cases talking about equitable estoppel and so forth, certainly not at all. As I indicate in the supplemental brief, about 50% of the people that appear before this court are going to be found. I don't know what the word would be, but I mean, there'd be more than just wrong when their position is not agreed with by this court. And I don't think just because you're wrong or you've made a mistake that you should apply the doctrine of equitable estoppel to a case.
In thinking about how this case could impact other cases, and I know we just deal with one case at a time, but is there a distinction between, I mean, it's the exception that someone is placed in a life sentence and then paroled, as opposed to a sentence and then a sentence and then placed on post-release supervision. Would there be a distinction between parole and post-release supervision? In other words, if it's just a determinative sentence that it's typically imposed off the guidelines, and the condition of post-release is that you pay restitution.
Off the top of my head, I don't know what the distinction would be. I don't know if the
parole board controls conditions of parole, and I'm not so sure on post-release if it's the same type of mechanism. I don't think it is.
I'm sorry.
That's all right. I know I'm putting you on the spot. Okay.
I know that obviously the 93 statute on restitution indicates the word parole because that's what it was at the time. So, unless the court has any further questions, I don't know what we'd request. I guess we'd respectfully request that the court take whatever action it seems fit. I think this is a somewhat interesting and confusing issue that I do think reduces itself down to a possible mistake. And I think that perhaps a remand with the appropriate parties or perhaps a civil action on the defendant would bring. I don't know. But this is about as far as as a representative of the 18th Judicial District, District Attorney's Office, as far as I think I can take it.
Any further questions of counsel? Thank you, counsel.
Thank you.
Reserve 3 minutes for rebuttal.
Mr. Chief Justice, I'm prepared to waive rebuttal unless there are further questions at this time.
Any objection to counsel waiving rebuttal time? No more questions? Thank you.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement. We now turn to the third case on this morning's docket. Isherwood's doing triple duty. This is case number 106865, State of Kansas v. James F. Williams.
Good morning. Adam Stolte with the Appellate Defender Office, appealing for the appellant, Mr. Williams. I request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. Your Honors, I was assigned this case about a month or so ago, and when I initially went through this case, I thought it was a simple kind of sufficiency of the evidence argument. And as I started going through it more and more, and in my preparations over the last week, I realized that there's a lot of underlying issues that weren't necessarily addressed properly in our brief. The first issue being which is now glaring, to me at least, a Prindy problem that there is in this, and a DECOM issue that is I just can't get out of my head on this case, and for those reasons, I would inform the court that I'm going to file a motion to file a supplemental brief this afternoon so I can more adequately address those issues. But in speaking to how this brief was argued,
What was the second issue, counsel?
US v. DECOM, it's spelled DECAMPS, but it's the lovely French, so it's DECOM. So what was argued at the sentencing hearing in this case was that defense counsel was really arguing that the evidence surrounding the event in Ohio, which is the prior conviction that we're dealing with on this case, failed to demonstrate an intent to permanently deprive to support the theft element of burglary. And it really kind of you have to kind of jump back on this one again, because in Ohio, there's the 1996 conviction. In Ohio, burglary statute at the time read that the essential elements were that the defendant trespassed in an occupied structure with the purpose to commit therein any criminal offense. That kind of speaks to one of the issues on DECOM, that the statute is more broad than what we have. Our statute for aggravated burglary, which is what this was considered, was that without authority entering or remaining into any building in which there's a human being with the intent to commit a felony, theft, or sexually motivated crime therein. And what they did at the district court level is try to pin this down to the theft element under our aggravated burglary to get this to be a person felony. So then after you see that, you have to look back at what they found below in Ohio. In Ohio's theft statute states that this is 2913.02, this is back in 1996, so that no person with a purpose to deprive the owner of property or services shall, and it kind of goes on, but it doesn't say permanently deprive. And so that's what was argued below. And our statute for theft requires a permanent action of depriving the victim on that case. And so the way this was argued at the district court level and also in our brief here was that it is basically an insufficient evidence to prove that the defendant in this case permanently deprived. The district court here used an indictment, a complaint, and one of the documents is eluding me here at this point, but in doing that, in making its analysis in this case, the district court violated really a Prindy by making a judgment on the facts. The district court said, in my own opinion, I believe that this is what actually happened. And what actually happened was, once the district court started doing that, they started violating a Prindy. They started making a determination of what happened below.
In the Ohio prosecution, was it a guilty plea or a trial?
It's unclear from the record. As
But
short as the
but
record
the
is.
factual determination of what occurred had happened either way, hadn't it?
I don't understand.
Well, I mean, the only fact that the judge here was considering was the fact of the conviction itself, not the facts that underlay the crime, was he?
No, he went straight to the facts of he went straight to beyond the fact of a conviction, and he did go straight to the facts of what happened below. It's on, I think it's in volume 2. It starts around page 2, I think, is when the state starts arguing that they start comparing the Ohio statute to the Kansas statute, and they say that, and they immediately jump in and say, if you look at the facts of what happened, based on the complaint, they say what we think happened was a theft, and that kind of brings back to the DECOM, is why I'm going to file a motion for supplemental briefing, is because the DECOM specifically says that is not allowed by district courts. They're not allowed to do that. They're not allowed to go and have this hypothetical situation of what occurred.
So in your understanding of now what's required with Apprende, or even what the trial court was required, how the trial court took its approach in determining whether or not the statutes are the same or similar enough to find that it's the same as our aggravated burglary, what at a hearing before a jury, or what the trial court was supposed to do is what? Because ultimately, I think as Justice Byers pointing out, isn't this a legal determination that the court must make, that the statutes are similar in order to find that it's a person felony?
Right, and that's when you first look at this case, you think we're just arguing about 3 months on a guy who's got a life sentence. But
I understand the significance between a person and a non-person. It's hugely significant.
Right.
But what I'm getting at is the determination that the statutes are the same, so the court can find, yes, that's a person felony.
Right, and that's kind of
And
where...
I don't understand why that isn't a legal determination, that is not a finding facts that a jury would have to do. And first of all, that first prong, but isn't that what the task is?
That's what the task is. The task is to make a legal determination, and that's what the DECOM says. It talks about 2 other cases, Taylor and Shepard. And in those cases, they talk about divisible and indivisible statutes. And depending on whether or not you have a divisible or indivisible statute, use a couple different, 2 different methods of determining whether or not the prior convictions, how they can be classified. It basically comes down to this. It basically comes down to, you're not allowed to re-litigate the facts of the prior conviction. You're only allowed to make categorical decisions. And so if a statute is divisible, which is a statute that has alternative elements like our burglary statute here, you can commit a burglary in a dwelling, a car, a boat, or airplane. So that makes that divisible to that element. And so what you do there is you use the modified categorical approach, which is talked about in DECOM, the Shepard case. You can look at the indictment to determine which alternate element was used to get that conviction for burglary. In this case, we can look at the alternate elements, or we can look at the indictment to determine that was a dwelling or a structure for these purposes here. But you can only make an elements comparison. You can't compare the facts of what actually happened. And in DECOM, the Ninth Circuit reversed the Ninth Circuit, because the Ninth Circuit was going through and making these hypothetical approaches as to what actually happened. And again, I think I can word it better in a supplemental brief. But
so basically,
as
I understand it, basically what you're saying, and I think that was your point, is that the Ohio statute requires any criminal offense,
right?
And for aggravated burglary in Kansas, it's limited, or not limited, but it includes a felony, theft, or sexual battery therein. And any criminal offense can encompass anything. You don't necessarily go to the facts, and therefore it's broader than what we are. So it's not comparable.
Exactly. That's the analysis. And DECOM relied on, I think that was the Taylor case to do that. Because
if we
it's broader,
disagree with you as a everything over? I mean, if we say that comparable means comparable, not identical, and that a criminal offense is comparable to any felony or theft and aggravated battery, does that resolve it? Regardless of what the district court may have done on fact-finding or whatever, if those are comparable statutes, isn't the issue over?
I guess we have one more court. But
I'm sorry, what?
I don't think it can be resolved in this case because it's broader. It's broader and actually on two different
No,
ways.
that wasn't my question. My question is, if we decide they're comparable, do we need to look at anything else? Doesn't that resolve the issue?
No, I think you do need to look at. I think you do need to look at DECOM on this case, and especially in its analysis of the Ninth Circuit's decision, because that's essentially what happened. What happened here in the district court level is that the district court level said, "Well, it's close. So let's look at the underlying facts to determine what actually happened here." And that's what the DECOM case says, is that you can't do that. You're not allowed to relitigate these facts. And it cited specifically to Apprendi in the defendant's Sixth Amendment right to jury trial and have a jury determine the facts in the case. But it also cited a more practical approach too, which is where looking at these documents, it's to determine what actually happened is not reliable, because the defendant in this case may not have had a dog in a race, so to speak, to argue whether or not a theft occurred.
I think
Because
what
it
my
was
colleague
irrelevant.
is, I think what my colleague was trying to suggest is that the district court may have been right for the wrong reason.
Okay, I don't think they were right. I think they were wrong to make this.
I think the
a personal.
rationale was wrong.
No, I think their ultimate decision finding this to be a person felony was wrong. And actually, the more strictly that you view DECOM, it really points to eliminating use of this prior conviction altogether. And that's kind of another reason for the supplemental briefing. It's because where DECOM says that where it's overbroad and it includes a broader swath of possible offenses than you're trying to compare it to, it can't be used. And that's, period. It ends the sentence right there. It cannot be used. As I was saying before, that one of the practical approaches for this is because Mr. Williams in this prior conviction, it didn't matter what the criminal offense was. It didn't matter. He didn't have to argue theft. He didn't have to argue anything. Any criminal offense worked. So whether or not he was arguing whether a theft occurred or whether, I think below he argued that he was going to staple stuff on the wall, so some kind of criminal destruction of property or something. It doesn't matter, and that's why DECOM is important here, is because it doesn't matter that he was charged with theft. It doesn't matter that he was charged with anything, and so that's why we can't use this prior conviction.
I'm understanding you basically argue this is a legal issue. We don't look to the facts, but that when we look at this just kind of on its face, that because the Ohio statute cuts a much broader swath than the Kansas statute, as you said, that they simply aren't comparable.
Right. Right. Because it's so broad. I mean, when he was in Ohio getting this conviction here, he could have argued. I mean, he couldn't have known that he was going to be here in Kansas and facing this or with this charge here. So he wouldn't have, when he was in Ohio, he wouldn't have necessarily had to argue whether or not what the underlying offense was for that, for the burglaries, the Ohio burglary statute. So arguing whether or not a theft occurred now is where the violation of Apprendi occurs, because we're now litigating facts not actually that shouldn't be relitigated, and it's clear from the comment that's the route we're supposed to take.
Just so I'm clear, you're saying as a matter of law, given the way the Ohio statute is worded, we simply cannot perform any kind of a comparative analysis. We're just done. And
Right.
so we can't look at any other statutes in Kansas, criminal statutes, to see if they would be comparable. It's just a pointless exercise.
As my understanding of DECOM has developed over these this last month, really, I mean, that's really what DECOM says. Where it cuts a broader swath, it can't be used, because pinpointing where they stopped arguing, what they argued is really impossible. And really under Taylor and Shepard, it really becomes irrelevant under the common analysis.
And the cases you've been discussing with us today is the first time we've heard about these from your side. Is that correct?
Yes, Your Honor. That's the reason I'll be filing a supplemental brief or requesting a motion to.
And I'm kind of curious how is opposing counsel to respond to the cases you've discussed with us today other than his hearing about them?
I think at least Apprendi is an issue that's widely known, and I think the COM is at least in defense circles, is becoming a pretty widely known case as well.
Just so I'm clear, was there any indication from you before you spoke today that we were going to be receiving any kind of supplemental authority from you, whether it was a 609 letter or supplemental briefing?
No, Your Honor. But when I had the aha moment after the 609 timeline had passed.
All right. Any further questions? Thank you, counsel.
Thank you, Your Honor. Thank you.
May it please the court, Assistant District Attorney Boyd Ishwood on behalf of the state of Kansas. And this is the part of the day in an argument where I either really clarify things or really embarrass myself.
Well, help start clarifying.
Okay.
In 2001, this exact same conviction was utilized in McPherson County, as I understand it, and was assessed or was as a non-person felony.
That's correct.
And now you're turning around 10 years later and saying it is a person felony. And how does that work?
Well, I don't know that there was I don't think the record indicates that there was a hearing in McPherson County. I think what you're suggesting is possibly some kind of res judicata or law of the case. And
not necessarily that, but why can't a defendant rely on a prior understanding and a prior utilization in a sentencing that impacted him, and there's been no change in the statute as far as I understand in terms of making it a non-person to a person. It's the same statute applies. Why can't he rely on that when trying to determine what is going to be the impact of my plea?
Because I don't think that there had been a hearing on that on the merits of it. I don't think that it had been determined, and I could be wrong. I'm not privy to the ongoings of McPherson County. I don't believe there was a hearing on the merits is the short answer.
Okay.
But with my second attempt to clarify, I guess I'm going to start at the beginning. I always find that a great place to start. And it's my understanding that there may have been a lot of confusion at the district court level because in my estimation, what's happened here is the defendant's counsel, the only argument was whether it was going to be a non-person or a person. Defendant's counsel indicated, well, you can't show an intent to permanently deprive, therefore it's a non-person. The intent to permanently deprive has no bearing whatsoever on whether it's a non-person or a person. The intent to permanently deprive only has bearing on whether there was a crime, which is something that he is not allowed to dispute at the time of sentencing. That is my understanding, and again, some of this is coming for the first time right here or right over there, but I thought De La Cruz indicated that you are not allowed to attack your prior convictions at sentencing. You can tell me it wasn't yours, and we can prove it's yours, but you can't just attack, well, you know what, there's an element of the crime that I don't think happened, so you can't count that. The defendant is not entitled to do that. The only issue was whether it was a person or a non-person. Whether there was an intent to permanently deprive doesn't change that. In Kansas, burglary is a person if it happens in a dwelling, or it's an aggravated burglary if someone's present, whether it's a dwelling or not. That was the only issue that should have been before the district court. Not claiming to be psychic, but having an understanding of what is going on in the law, I am somewhat prepared to speak to, I guess, DeCamps, or however it's pronounced. It was my understanding that if it was a divisible statute, that you could look at relevant, a limited source of relevant documents to determine whether an element was present. And I think in this case, even if you look at original opposing counsel's brief, they talk about an indictment, an Ohio indictment that indicated that it happened in an occupied structure. So if that's the only issue that makes it a person or a non-person, then we can look to the limited category of documents, one of them being the indictment, clearly indicates it was occupied, making it a person felony. But again, it would seem to be a little late at the podium to request a supplemental brief that changes your issue completely. As we indicated in our brief, the only issue that the defendant continued from below into his brief was that there was no intent to permanently deprive. That doesn't get you anywhere. That's a non-starter. It gets you nowhere. It doesn't have any impact on whether it's a person or non-person, and it's not something that you can complain about at the district court level. The only thing you can complain about your priors, two things, not mine, one, not counsel. This isn't that. So we would ask the court to address the issue that was briefed. And that issue does not find any relief for the defendant. And I think I've supplied, in the event that this court continues on and addresses the issue from the podium for the first time, I think I have accurately indicated another way that the district court could be correct, obviously not for the reason because that wasn't challenged below. But I do think you can look at a limited category of information, and I think the Ohio indictment would fall within under DeCamp, whatever. Unless the court has any questions about either the issues briefed or the issues from the podium.
Well, let me just clarify here. So if in Ohio, the defendant went into the structure with the intent of littering, that would satisfy the aggravated burglary statute in Ohio.
Well, now
is that a similar type? I mean, we're just looking. So what you're saying is that doesn't matter.
Well, I think
that doesn't matter because that's a felony in Ohio under their, call it whatever it is, aggravated burglary statute. In Kansas, that is not an aggravated burglary.
Well, I think it was Justice Johnson. Two things, I guess. One, I think it was
that comparable? I don't know if it's
comparable. That's where I was. You
think that's comparable? Going in and I'm going to litter. I'm going to do some criminal damage, which would make it a criminal damage case in Kansas, but it wouldn't make it an aggravated burglary. In Kansas, and is that comparable?
Well, I don't think that the comments from Your Honor are possibly comparable, but I think that if you look in the indictment, and this issue is being brought for the first time for the podium, and I cannot recall. I remember from the briefs that the judge had indicated there was something about the theft of a stapler and something else.
And knife.
Yeah, and I think that was. I don't know where he got the information, which compounds the issue, because you can only look to certain. I don't know where he got it, and I don't think that the Ohio case was a plea. I could be wrong. So I don't know where that information came from. So I don't know that, again, the issue raised below was simply whether it was a person or a non-person. And the claim of whether it was an intent to permanently deprive gets you nowhere under that. And I think I've done the best I can from the podium of for the first time, advancing the argument as to how you can, if you choose to allow the defendant to make a new argument from the podium about why it shouldn't be included, and now defendants get to attack every conviction at the time of sentencing on any element whatsoever, then I think I've advanced the argument as far as I can for the first time.
Any further questions of counsel? Thank you.
Thank you.
I think I can start by apologizing for kind of dropping this on the state's lap here this morning. But to address kind of the argument that was raised in the district court, I think the argument that was raised in the district court was whether or not it was permanently deprived, which is the first step in determining whether or not it can be a theft. If it can't be a theft, it can't be an aggravated burglary. And so I think that's the argument that that was made at the district court. I think that you can find in our favor based on that argument as
That's
well.
a factual argument.
It's a factual argument, which is, again,
So what about Dela Cruz?
I am unfamiliar with Dela Cruz at this point, Your Honor.
Okay.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement. That concludes this morning's docket. Court is now in recess until 9 o'clock tomorrow morning.
Rise.